Welcome to Canadian Law Tutor. We have been having a conversation with you and providing you on opportunities with our platform to learn about the Canadian law. Today, we have an esteemed guest over here who is going to give us knowledge about what we need to learn within the constitutional framework of Canada. As we know that reconciliation is a path to be followed for many years to come. As an international legal community, we are joining Canadian legal landscape every year, and somehow we find ourselves a little bit confused about what does reconciliation means for our constitutional framework, legal framework, and what is our duty as lawyers in the process, what we need to learn. We have never lived in this country before. We probably joined at the age of 20, 30, 35, and we already are conditioned in the common law precedents of law, and our training is based on common law precedents. Within this, we have another legal aspect in Canadian law, which is Indigenous law. And common law, Indigenous law, constitutional law, how they shape the future of Canadian law. We are having this conversation with Tom. Tom, thank you very much for joining us today and giving us time and opportunity to learn with you. Tom,
it's my pleasure and my honor.
He's a general counsel with Truth and Reconciliation Commission, and there is no other person better than him for us to learn about the reconciliation path, how it's going to impact the future, and how it should shape the law of Canada in coming years. Thank you very much, Tom. So over to you. You don't need an introduction. I am honored to have you on my platform, and you are giving others an opportunity to learn the law from you. Thank you very much. So please tell us your a little bit about your experience about coming to this reconciliation process. How do you first came across this platform and you started contributing on this?
When I graduated from law back in the 1980s, I took a job with the Department of Manitoba Justice. And there were two, in the 1980s, there were some important things that happened in Canada. There was an Indigenous man called Donald Marshall Jr. in Nova Scotia who was wrongfully convicted of murdering another person. And they had a royal commission to study how the justice system dealt with Indigenous peoples and Black Nova Scotians. Shortly after that, there was a trial that happened 16 years after an Indigenous woman was murdered in Manitoba. And the trial, so the question was, why did it take 16 years? And of the 4 men who abducted and participated in the murder of this Indigenous woman, Helen Betty Osborne, why was only 1 convicted? And just after that trial happened, an Indigenous man in the streets of Winnipeg died from a gunshot from a police officer's gun. And the police said in less than 24 hours that they had completed their entire investigation and that the police officer did nothing wrong. And as a result, the province of Manitoba, the government of Manitoba, created a special inquiry into how the justice system treats Indigenous people. And Judge Murray Sinclair was one of the commissioners who was appointed. And he and his co-commissioner, Alvin Hamilton, appointed me as the executive secretary for the Manitoba Aboriginal Justice Inquiry. And that went from 1988 to 1991. So that was my first exposure in a professional way to these issues. After that, after the inquiry ended, I joined the Federal Department of Justice for many years, but I never worked on Indigenous issues. And then in 2009, the Truth and Reconciliation Commission of Canada was created, and Justice Murray Sinclair was made the chief commissioner, and he asked me to join the commission. So I was with the commission for the entirety from 2009 until 2015. And then after 2015, I retired. And now my retirement hobby is to write very detailed legal research papers on how the justice system treats Indigenous peoples, especially in relation to Indian residential schools. But I recently, the last several years, I've been focusing very much on the history of how Canada got to the point where we actually thought Indian residential schools were a good idea. So that's my background and my history.
Thank you very much. I know you don't need any introduction, and you are such an esteemed academic person in law who has written 20 articles on Academia EDU, and I have started reading your Canada's Oath to Queen, and I've started reading that slowly, and I hope I can do the justice by my diligent reading in the process. I love reading it. Anybody in our audience who want to learn more about that, and you ever feel there is a gap in your syllabus, your gap in your learning, you can go there and download those free information. I would be providing the links in my video chat as well, so that you can have those conversations, those wonderful pieces of information and knowledge as part of your reading list in 2022.
And when I thank you for that, and in addition, I post many information, many articles on my public figure Facebook page. So anybody can go to it, Thomas McMahon or hashtag McMahon Equality Rights. And in addition to my research papers, what you will find there are articles about equality for all peoples, not just Indigenous peoples. So my focus is on equality for equality generally.
That's the biggest pillar in any democratic country. If we believe we can giving everybody an equal opportunity and equal justice and equal recognition, then we need to have the equality understood in its true sense.
And I believe that you can't have freedom without equality.
That's wonderfully put. That's great. And tell us a little bit about your equality research. How do you see that in the current Canadian system, where you see the future of equal opportunities?
So I find that when you read about Canadian history, Canadian legal history, Canadian law, it gets divided up into categories. And so over here, we'll read about the law as it relates to Indigenous people. Over here, we'll read about the law as it relates to immigrants. Over here, we'll read about the law as it relates to women, as it relates to homosexuals, as it relates to Black Canadians, Japanese Canadians, Chinese Canadians, all these different categories. And what I am concluding is that Canadians generally do not connect the dots. They do not see how most of these things are very strongly connected. So when we have racial discrimination in Canada against refugees, against immigrants, against temporary foreign workers, against Indigenous people, against African people, we don't see it as being all part of one thing, which frankly is white supremacy. And I think that it is important that we understand that the inequalities that we have had in Canadian law over the years are not particularly aimed at one particular group. It's not discrimination against Indigenous people. It's frankly, it's been our history is discrimination against anybody with darker colored skin.
That's right. And I had this a little bit of difficulty in starting when I started my business and started working. I would introduce myself as a, person who teach law, they were mostly telling me that probably you are only translating the law to people of your own community who may not be able to read English. So it was never meant, it was never understood in a way that it is more like, teaching law and as a lawyer. So I think that was the biggest hurdle for me to
Right.
cross.
So you start from a point of lack of respect.
Right.
And now you have to climb that mountain.
Right. That's correct. And then when we talk about equality, we should be, if a person comes with the designation of a lawyer or a law student, and they would be able to, recognize as any other law student in our country where they can, they
Right.
should at least given an opportunity to perform their skills and improve their skills. Life is a learning curve for everyone.
Continuous learning. Everybody has to do continuous learning, and everybody has strengths and weaknesses, and everybody knows something, a lot about something, and then not very much about something else. And I think we have to be aware that we all have these similarities and different knowledge bases.
Thank you. So my audience is mostly people who are coming from, foreign law countries, and they do not
Right.
understand Canadian, system in a way. As a Canadian students who learn law in school, basically social sciences in the school. So I believe
Right.
law also has to give you information what the social science would you learn in grade 6 to 10 or 12. And that's where you develop a thinking, in the process. And now as a lawyer, coming from outside, settling in Canada, you learn this new subject called Foundation of Canadian Law. And there are two concepts in that, which students find it elusive. A little bit is the fiduciary duty, because we understand fiduciary duty more into the sense of a doctor-client relation, doctor-patient relationship, lawyer-client relationship. But why fiduciary duty is a wider concept when it comes to Indigenous communities, Indigenous promises made to the Indigenous people and the government of Canada. So please explain them, how would you put fiduciary duty as a responsibility of government of Canada, and how it is a little bit different when we think it from the common law concepts. In common law, fiduciary is a very basic principle, which everybody else, I think in the 80% of the world follows it.
Right.
And they understand it. But when it comes from fiduciary duty of government of Canada,
Right.
it is
So
something is a new concept to be learned.
So I'm going to say some things that might surprise you. Canada was an Indigenous country. Everybody, well, I mean, the entire world was. Every single person on earth used to be Indigenous. And frankly, most of us are Indigenous to some place or other. Canada was Indigenous. And then the Europeans, and in particular England and France, decided that they wanted to take all of the land. And they came over and they started making laws, and they backed their laws up with rifles and guns and ammunition and armies and gunboats, and they took all the land. And they did it with creating their own laws. And the current reality of reconciliation in the Supreme Court of Canada is that the courts like to use fancy words to try to paper over, to cover up the reality of what has happened. So when the Supreme Court of Canada talks about reconciliation or fiduciary duty or honor of the crown or sui generis rights, what they are saying is we have to find a way to be a little bit nicer to Indigenous peoples so that everybody will be quiet about the fact that we stole all of the land. I don't personally know of any single court case in Canada where fiduciary duty decided the question. Um, so even though the courts use the words fiduciary duty, they also say that the fiduciary duty owed to Indigenous people is not like fiduciary duty in all those other contexts that you mentioned. And then they start whittling it down and making it less and less important. And ultimately, fiduciary duty does not actually make the difference in law. The courts use the words. As lawyers, we are told to use the words, just so long as we never ever talk about stealing the land, taking all of the land, white supremacy, discrimination. Don't use words like that, the courts tell us. Use words like fiduciary duty. So I don't like the term fiduciary duty. I think that this is a game of colonialism and colonial vocabulary that is used to preserve our constitutional reality today. And the constitutional reality is we took all the land, we put in a parliament and some provincial legislatures that are based on England, and English people in particular and white-skinned people generally make all the decisions about what the law will be. But the most important decision is we are never, ever giving the land back.
And how do you see fiduciary duty if you have to? That is one way of putting the way Supreme Court of Canada has been avoiding to give it the true definition where it came from. And so we have a term in which we believe that it is not given that meaning which it should have in the context of a reality of law. So what do you think should be the meaning of fiduciary duty if we have to summarize it to a person who is coming to Canada as a law student or as a lawyer?
So my preference in my belief is that we should not struggle trying to understand fiduciary duty and Indigenous peoples. I think where we should be focused is on Section 15 of the Canadian Charter of Rights and Freedoms. That is the equality provision in the Charter. And I think that almost all of the legal issues involving Indigenous peoples in Canada can be most properly dealt with under Section 15 of the Charter. Now, in addition to Section 15, there's Section 35. Section 35 is outside of the Charter, what we call outside of the Charter. Section 35 is the one that specifically refers to Indigenous rights. And it essentially says that we recognize whatever Indigenous rights may or may not exist. It's a very oddly worded section.
But when I studied that section back in 2009, and I tried to summarize and I started teaching constitutional law in 2000, back in 2010, I used to start saying in my class that it is the most grammatically legal fraud.
Well, there you go. And one of the ways that people have used to describe Section 35 is some people think it's an empty box, that there are no rights in it at all. And
Right.
Some people think it's a full box, that it's got all the rights in it. And at the end of the day, it has not made a lot of difference. Section 15 of the Charter has made a difference. Very, very belatedly, very, very slowly. But Section 15 of the Charter has made a difference. In just 2021, 2022, actually, right now, we are in the process of settling class action lawsuits concerning discrimination against Indigenous child welfare in Canada. And that has been going on since 2000. The legal fight has been going on since 2007. And it has been going on through the Canadian Human Rights Act, which is very similar to Section 15 of the Charter of Rights and Freedoms, not identical, but similar. But the issues are the same: discrimination and equality. And so Indigenous child welfare is being settled in Canada today, and we're waiting for a couple more months before the settlement agreement is finalized. And it is being settled through Section 15 and through the Canadian Human Rights Act. It is not being settled through Section 35 of the Charter of the Constitution. It is not being settled through fiduciary duty, duty to consult, honor of the Crown, any of those things. It is being settled on the principle of equality and discrimination. Similarly, same thing. It just happened last year, 2 years. Canada has discriminated against Indigenous women and children, and Indigenous women in particular right now I'm talking, since before Confederation. So since the 1850s, we have discriminated against Indigenous women. We have told them that if they marry anybody who's not Indigenous, they will lose their status as being Indigenous. But if an Indian man, an indigenous man, marries a white woman, the white woman all of a sudden becomes Indigenous. And so in this way, with these laws, we told Indigenous women that they are less important than Indigenous men. We told them that they have the lowest status of anybody in Canada. They are the least important people. And this is how we dealt with Indigenous women. And this issue, the status, the discrimination based on Indian status against Indigenous women, has only been resolved, I want to say 2019, might have been 2020, very, very recently. So the entire Canadian history of discriminating against Indigenous women has been done in law and has not been resolved until the last year or two. And it was resolved using the principles of Section 15 of the Charter and discrimination and equality. So for me, I believe that the most important ways to think about how we treat people in this country is by focusing more and more on Section 15 of the Charter and on the questions of discrimination and equality. And I think that all the other words, the fancy words that the Supreme Court uses, I don't think they're honest.
So you see the future of Canadian law on the path of reconciliation within the constitutional framework, and you believe it's more in the realm of the Charter of Law rights.
I do, because nothing else has worked. You know, treaties between Canada and Indigenous peoples should have worked. They did not. Section 35 of the Charter should have worked. It did not. So what's left? Section 15 of the Charter should have worked in 1982. It should have worked in 1985. It should have worked anytime before 2019, 2020, but it did not. But it finally did. It took a long, long time. It took a lot of determination by Indigenous peoples and their lawyers. And it took class action lawsuits. No class action lawsuits, no victories.
Right. No, I think the strength is in unity in any circumstances where you stay strong, stay resilient through the process.
And the unity is an important point, I think. It kind of goes back to what I said earlier. Everybody on Earth has kind of their own sort of constellation of legal rights. As a male, as a white male, I have a certain constellation of rights that are different from my wife because she's a woman. She is capable of being pregnant. She has different biological needs. And so she has some legal issues that I don't have. And you can say that for everybody. Indigenous peoples, because they were the original owners of this land, have their own rights. And immigrants have their own rights under the Citizenship Act and the rights that come with them when they come to this country. Refugees have different rights than immigrants. So all of us have kind of different set of rights. And I don't think that we should be competing against each other saying, you get more rights than I get. It's not a good attitude. I think we should be more unified, saying, look, these are my legal rights, respect my legal rights. These are your legal rights. We will respect yours. We should not have, in my view, competition between new Canadians and Indigenous peoples. We should recognize that, frankly, all of the new Canadians and Indigenous peoples have to face very similar challenges in law in Canada, and those challenges are discrimination.
Right, and we are in a democratic country where we can stay angry. I love that part of being a Canadian, that we can say I'm angry, I can say I dissent, I say I differ in opinion, and we have a legal framework where we can address we can expect our grievances to be addressed within the within a democratic way and a constitutional way. That is the beauty of Canada.
And as lawyers, we can act on that. We can say, you know what, I'm responsible for my own rights. I'm responsible for my community's rights. I have the knowledge and the skills where I can help them, and I'm going to do it.
Right. So how would you sum up the one notion, which is mostly in the, other people coming from other country, they think that Indigenous people, they are considered more like a social burden from the aspect of understanding of other people rather than understanding that it is our responsibility to bring them back. And that's where the reconciliation process works in the most effective way. Right.
So, and I've had this conversation with Justice Murray Sinclair in the past. The commission was the Truth and Reconciliation Commission. And my job mostly had to do with collecting historical records and current records to help us write an accurate history of Indian residential schools and the treatment of Indigenous peoples in Canada generally. And so I say that I am much more concerned about the truth than I am about reconciliation. And I would say to new Canadians, until you have learned the accurate history, the accurate truth of what we did to Indigenous peoples and are still doing, then you really haven't got enough information to be judging people or to be thinking of them as social burdens. So I focus on learning the truth for myself, writing about the truth, and encouraging others to seek out the truth and to not judge others, because there's a very good chance that you don't have a full understanding of the history and the realities of what happened. I'll give you an example, the Citizenship Act. So when Canada finally got around to creating its own Citizenship Act, it did not include Indigenous peoples of Canada. It's unbelievable. 5-6 years later, they were kind of sort of included in the Citizenship Act. But it tells you just how little we cared about them or thought about them, that the first Canadian citizen ever was Canadian Prime Minister Mackenzie King. You couldn't have a more British colonial name if you tried. And he was deemed to be the first Canadian citizen. And we've had Indigenous peoples living here, owning the property, caring for the land for between 6,000 and 12,000 years and maybe longer. And none of them were the first Canadian citizens. That makes you think.
Right. Well, that's very informative. I now can truly say that when you said in the beginning, like I may surprise you. Yeah.
So I'm a bit outside maybe the mainstream, like the correct and polite way to be a Canadian lawyer and to get along is to use the language of the colonizers, adopt their vocabulary, speak their vocabulary, don't question it. Don't tell them that white supremacy is a reality in Canada. Don't tell them that it's a problem. Don't tell them that we have discrimination and in this country that needs to be addressed, and that the people who are being discriminated against in this country are being discriminated against in different ways, one from the next. We discriminate against Indigenous peoples differently than we discriminate against Indo-Canadians, against Chinese Canadians, against Japanese Canadians. Each of them have been the recipients of our discrimination, but always in different ways. And that makes it more difficult to feel a common unity with the others.
Right. So when I work as a mentor in the professional development program for women who are from my community and some other South Asian communities, and nobody understands their battle, that they have already fought a battle by just coming to law, because they may be having an adversity in this. So we need to be a little bit more passionate, about their achievements, a little bit more compassionate about when they are making a mistake, and giving them more inclusive precedent, encouraging them to stay in the profession and excel in the profession. And
Yes.
so the definition of a Canadian lawyer is everyone. And
Yes.
I've started a group called Women in Law in Canada to just give a definition of law in Canada, that it's all inclusive, and diversity and inclusion is more than the words, it has to be in the action.
Right. And like I said earlier, you have to work at it.
Right.
Nobody gives it to you. You have to work for it and take it and demand it and use the vocabulary that is accurate about it.
Right. And I think Ruth Ginsburg has very nicely put when she was saying, I dissent, I am here just to dissent so that I can say that this side of law keep evolving, keep being heard in the process, because somewhere in the future we may be able to have that conversations in the more meaningful and effective way.
Right. And I do believe that things are getting better. I always believe that things are getting better. So things are never perfect. We always have challenges, but I truly believe that Canada has become a better place over the last 150 years. And I'm glad for that. And we still have work to do.
Right. No, this is the first time I learned the difference between word Aboriginal and Indigenous was from my son in grade 4. He told me, he says, Mom, you cannot use the word Aboriginal. You need to use the word Indigenous. This is what it means. I always read in my constitutional law written by Professor Peter Hogg that it's Aboriginal, and I've never understood the difference. So he explained it to me. Then I made a post on that, and then I shared on social media to educate others as well. So my philosophy is more, as I learn, I share with everyone. So today is my opportunity to learn from you. So I'm sharing this.
Right. So just on that point, right? So my first job was with the Manitoba Aboriginal Justice Inquiry, and Justice Sinclair said, we're going to use the word Aboriginal. That's the word we're going to use. We're not going to use the word Native. We're going to say Aboriginal. And then 30 years later, the vocabulary changed, and people said, no, we don't like Aboriginal anymore. Now we want to use Indigenous. To my way of thinking, the literal meanings of the word are the same. But people want to use Indigenous. I respect that. I'll use Indigenous. It makes no difference to me because the words mean the same.
Right.
But today we have the United Nations Declaration on the Rights of Indigenous Peoples, and that is the choice, and I respect that.
Right. And how do you see the global citizenship concept as a path to reconciliation?
Well, I'll put it this way. I think that everybody needs to learn their own history. I think, let's talk about India. I think that everybody from India needs to understand as best they can what colonialism did in India. I don't know how a person from India is going to properly understand Indigenous peoples in Canada if they don't compare it to having England as the colonial masters in India, because that's the situation. Both peoples were colonized by England. England took the resources from both countries. England imposed its laws on both countries, but it did it in different ways because they're different countries. And so you don't have an identical form of colonialism, but you do have colonialism in both places. And it is, frankly, in my opinion, it's based on skin color. And I think that if people would really learn their own histories and then say to themselves, so these other people over here, the Indigenous Canadians, they have a history that's a lot like mine.
Right.
I think that would be helpful. I think that would be helpful for reconciliation, and I think it would be very helpful for truth.
Thank you. No, that's very nicely put. So as we going back to our conversation of Section 15 as a source of our reconciliation, I would say, in the process, because we cannot start the healing process unless we understand the equality in the true sense. And unless we decide to implement the equality in its own meaning and let it enshrine in everyone and let it empower everyone out there who feels because equality is more like having a subjective experience in the process. I may have
I think that's right. I think for me, any struggle for equality, any victory for equality promotes everybody's equality. So let's say that I'm fighting for the rights of homosexuals and I'm fighting for their equality. In my opinion, when you win a battle for gay marriage or something, you have increased the ability of the legal system and of Canadians generally to feel more compassionate, to feel better informed about equality for all peoples. I don't think that there is any equality struggle that is more important than the next one. And I think all of them help each other.
And I think that's why somewhere the framers of the Constitution let it be, give it a window to evolve on the analogous ground so that it can leave it to this, interpretation as subjective analysis as we go along. Because my comparison to discriminative ground can be something different than yours. You can think as a white father who has not been understood as a compassionate caregiver for the child. So we have some parents who feel that justice system discriminate against the rights of the father in the child custody issues. I may feel as a woman that I've not been understood as a woman of color as being able to interpret the law. And as a lawyer, I was more considered in the beginning as a translator rather than an rather than a teacher or being able to have a dialogue on the law.
Right.
Right. So I believe that is where analogous ground can be understood by anyone who wants to understand what Section 15 says specifically, then leave it for the interpretation on the analogous grounds so that we can come up and have a theory and let it happen in the future.
That's right. That's right. That's right.
Yeah. So when we talk about the sui generis and those kind of components in the relationship to the law and relationship to the land, how would you explain Aboriginal title to my audience in your own opinion?
That's a good question. First thing is Aboriginal title, Indigenous title. It means they were the first owners of the land. You, in law, in anybody's law, the first owners are the legitimate owners. And then what happens is we try to come and take that away from them. So that's the struggle. And we do it in different ways. We entered into treaties with a lot of Indigenous peoples in Canada and almost nobody in British Columbia. So British Columbia is where almost all of the Aboriginal title cases are coming from because there's no treaties. Now the treaties, frankly, we didn't respect, we didn't implement, we didn't honor, we didn't obey for the most part. But still, the treaties have created problems in the rest of Canada for people trying to establish Aboriginal title. For sure, First Nations in British Columbia also have problems establishing Aboriginal title, but at least they don't have treaties making the struggle even more difficult.
So you believe, sorry to interrupt you. So you believe
go ahead.
treaties are more hindrance to the claim rather than a facilitator to the claim?
I think that there is a reason why almost all of the Aboriginal title court cases are coming from British Columbia. And that reason is no treaties. So yes, I do think that treaties have been a hindrance in the rest of Canada for First Nations asserting Aboriginal title.
Right.
And I say congratulations to the First Nations in British Columbia who have been fighting the fight for many, many decades. This is nothing new. This has been going on for a very long time.
Right. And how do you sum up the definition of Aboriginal title based on your legal research? How do you see the future of Aboriginal title
right.
Again, tie up to the path of reconciliation, how you see that?
So Aboriginal title is saying, recognize us as the original owners of the land.
Right.
And Canadian law says, well, we won't. We just won't. We will not give the land back. So what we will do is we will just invent certain rules that will give you a little bit more control over your traditional territories than you used to have. And we hope that that will be good enough for you. But we're never giving the land back, and we're never going to tell you that you decide how the land will be used. We will go down that road as far as we can without giving you the land. So in the end of the day, Aboriginal title is all about who controls the land, who decides what the use of the land will be, who decides what laws will be on that land, and Canada will never, ever go back. So even where we say, yes, you have Aboriginal title, there will be limits and exceptions and qualifications on that. We simply will never give full Aboriginal title to any Indigenous peoples.
And how do you see Aboriginal rights and the commercialization in the future? Let's say, what is your hope and vision for the law based on your research for next 20 years?
So my hope and expectation is that Canadian law will A, stop discriminating against Indigenous peoples in important ways, and B, that even though I don't think that Canada will ever get the land back, I do think that we will increasingly just give more and more control to Indigenous peoples to govern themselves and to have important roles to play in deciding how their traditional territories will be used. So it's not the full Aboriginal title, but it is more than it has been, and it will get increasingly more. And it is a very good thing for all Canadians, in my view, especially when we talk about climate change today. But, you know, I'll phrase it in a different way. When you think about colonialism and when you think about white supremacy, we are the newcomers, we are the invaders. We have attachments to England and Great Britain and France in a way that Indigenous peoples do not. If you were ever to wonder which group of people in Canada are most likely to be independent of England, France, and the United States, I believe the Indigenous peoples are the ones most likely to be capable of being independent of those, of the colonizers. And I think that that will ultimately be a very good thing for Canada, very good thing for climate change. I think that only people who are willing to say, you know what, we don't have to have this industrial activity to make us happier. I think those are the people who have the best chance to protect our environment and to help us with respect to climate change.
Thank you. No, I really appreciate your, candid opinion for everyone to learn the law in the raw sense, and then they can have a thinking point. You have given us a lot to think as students of law. As we are all, even if we are tutors, teachers, lawyers, practicing lawyers, non-practicing lawyers, or trying to become a lawyer in Canada. There's a lot to think about the jurisprudence of law and future of jurisprudence in law in Canada.
And I would add one more thing. You began by mentioning that you've been reading my paper on Oath to the Queen, and I think it is very bad that we force new Canadians to swear an oath to the Queen of England, because we do not force Indigenous peoples to do that, and we do not force most Canadians to do it either. So why are we doing this? Why should new Canadians swear an oath of allegiance to the Queen of England in order to become a Canadian citizen? I think that it puts words in the mouth of new Canadians that divides them away from Indigenous peoples. I think it is a divisive set of words. Nobody should have to swear an oath of allegiance to the colonizer as a condition for being a good Canadian. But here we are.
And we are an independent country, and we can have allegiance to our own country. And it's Canada is giving us everyone so much better.
That's right. All anybody needs to do is to say, I will obey the law.
Yes.
You know, I'll be a good Canadian. I'll work hard. I'll obey the law. Thank you very much.
Yes. And the best part of being in Canada is we learn so much from our neighbors. We have such a inclusive environment so many times around us, even though it can be challenging in certain ways. But as a normal Canadian, they are very, very inclusive. They are very excited for you to be here and be part of them. They teach you a lot.
And that is part of how Canada has become better over time.
Right. And one more thing I would like to learn from you over here, and on this opportunity to learn law from you. How do you see customary law as a source in Canada in the future?
So that's a really good question. That's an important question. I'm going to answer it by talking about vocabulary. So we have this. We use these words, Indigenous law. Indigenous law has two very different meanings. When I was going to law school and going through my career, Indigenous law meant Canadian laws that applied to Indigenous peoples. Today, Indigenous law frequently means Indigenous laws that already exist within First Nations that govern First Nations. And they're not Canadian laws, and they're not laws that we enact to govern how Indigenous peoples live. So two very different ideas of what Indigenous law is. So Indigenous law that came from Indigenous peoples, came from Indigenous societies, were self-governing, that is what I think you would call customary law. That was what I think you just referred to. And I don't know very much about it at all. I know some, but not enough. Um, and I am excited about it. I am excited about giving Indigenous peoples the opportunity to be more self-governing in whatever way they choose. They do not have to have Indigenous law, customary law from 300 years ago. They can develop and adapt and choose new forms of Indigenous law for themselves, of customary law for themselves. I am really very excited about it.
Thank you. So you see customary law as a source of law as the years to come in the future?
I do. I do. And I also think that it will be changed and modified because that's what human beings do.
Right. Thank you very much. And as I see, we have seen feminist theory, economic theory, natural theory, or even we have a bijuralism within our legal system. We say we are bilingual, and at times we are bijural as well. So why can't we trijural at the same time?
Yes, yes. Bijural is a very interesting word. In the 1960s, it meant French and English. Now, I don't know. Does it mean Canadian and Indigenous? Maybe it does. It's just, it's a tricky word. For somebody as old as I am, I think about it in the idea of there were two founding nations of this country, and they were France and England. And that's just so hurtful to Indigenous peoples, and it's so inaccurate. It's just wrong. All immigrants are founding peoples. All Indigenous peoples are founding peoples. And the idea of bilingualism and bijuralism to put France and England at a higher place in our society is offensive to me.
Legal system.
I'm sorry?
I said, or in our legal system.
Right, exactly.
So you see bijuralism developing more from bijuralism, as understood, can be civil and common law, but you also see it as interpreted as Canadian and Indigenous law in the future.
Yes.
Because we have already recognized and established that we are bijural. And then we leave it on the interpretation as things come into the courts, like what bijuralism means for Canada. It can be any different thing. And again, we go back to analogous grounds. Analogous ground gives you an opportunity to claim equality based on what you believe.
Right. And all I'm doing is I'm just giving you a little historical warning about the word bijuralism. It had a very, very specific meaning in the 1960s I don't think it has anymore. But for an old Canadian like me, when I hear bijuralism, I think of French and English. And I don't think that's what you mean.
Right. No, in Foundations of Canadian Law, there's a specific term called bijural, and where we try to learn that supposing we are interpreting the system, supposing we are interpreting, something written in two languages. So how bilingualism further is evolved through the bijuralism, because when we have two legal systems, then we try to understand the things in those contexts as well. Even if we are interpreting Income Tax Act or criminal code, we cannot rely upon bilingualism. We have to think in the context of the bijuralism.
And that's correct. Everything you said is completely correct. I just warn anybody listening that the prefix bi, it's referring to French and English, and it makes other people feel left out.
Right.
And so I caution about that. At the same time, I do believe that honoring the French language and honoring the Quebec Civil Code and the civil law system from Quebec helps all of us become a better society, because now we have taken one more step towards diversity and recognizing diversity and recognizing the different legal rights of different groups. So while I don't ever want to tell anybody in Canada, any new Canadians, anybody else, that France and England are more important than others, I do want to say that French language rights are very helpful for the equality of all Canadians.
So you see diversity and inclusiveness in our future, considering more as evolving as Canadian in every aspect.
In every aspect. For me, equality is everything and diversity is everything. Nature is diverse, our environment is diverse, human beings are diverse. Nobody is better than the next person, and we should be equal and diverse.
And we should be respecting the diversity of thought as we evolve as the legal system, rather than being stick to one
Right.
interpretation of something. So diversity, more having people more on boards with different thought process, not just the skin color.
Exactly. Yeah.
Thank you very much. I was reading another book in which I learned about diversity from a brown woman's perspective. I'm going to share that in my next video and share it with you as well, Tom. Thank you very
Okay.
much.
Thank you so much.
Please summarize for us your journey as participating in Truth and Reconciliation Commission, and your gist of what you have been. It's so hard to put those things in one
Right.
or something.
So,
Tell us
so I
about
would say a few things. 10 years of my career was spent with the Aboriginal Justice Inquiry and the Truth and Reconciliation Commission. The Indigenous people that I met and worked with every day, and half of our office was Indigenous, they're all healthy, they're all happy, they're all hardworking, they all have great families, and they never show up in the newspapers. They never show up on television. These are not the people that you are exposed to, that Canadians are exposed to. We develop our ideas about what it means to be Indigenous from what we see on TV and in the newspapers. Well, my experience was completely different because I was working with Indigenous peoples who never made the newspapers, never made the TVs. Why? Because they were healthy and happy and loving and good families. And in that way, they just kind of fade into the background. There's no reason for them to be in the news. So I have a different world experience, life experience with Indigenous peoples than maybe others do. And then the other thing, to sum up my career, my experience on Indigenous issues, is the more you get to know people, the easier it is to appreciate them and to see them as individuals and to see their qualities. The less that we know each other, the more difficult it is for us to appreciate each other.
Thank you very much. I think more we need to understand from the perspective, having a respect for an established culture. They were running the show so well. They were running their problems in a really, effective way. And if we look at the future right now and the way global citizenship concept is there, and this is all embedded in the Canadian Indigenous laws and their customs and the culture. This is what they have been teaching from thousands of years. And there's
Right.
more to learn. So learning, I think reconciliation for lawyers can be an active process to learn.
Yes. Oh,
And
absolutely. 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 Well, I think that's probably exactly right. Reconciliation means learning.
Learning and step-by-step process for everyone involved in the process, so that wherever, if you're informed, you can have a more accurate interpretation or action if it is required and it comes to you.
Yeah, that's right.
Thank you very much, Tom. I really appreciate your time and your input, and it's been a wonderful learning session for Canadian Law Tutor and for our audience. I always look for an opportunity to learn from scholars in the legal field. Thank you very much. You have lived a wonderful life and you have done a wonderful career in law, and you are here to teach us, and we would love to have you again on our platform.
Yeah. Well, thank you so much, and I wish you and everybody who's learning with you all the best.
Thank you very much. So have a
Bye-bye.
great